A very good morning to all. Today we are going to discuss the section 54 Refund of tax. Subsection 1. Any person claiming the refund of any tax and interest, if any, paid on such tax or any other amount paid by him may make an application before the expiry of the 2 years from the relevant date in such form and manner as may be prescribed, provided that a registered person claiming the refund of any business in electronic cash ledger in accordance with the provisions of the subsection 6 of the section 49 may claim such refund in such form and manner as may be prescribed. The subsection 2 specialized agency of United Nations organization or multilateral financial institution an organization notified under the United Nations Privilege and Immunities Act 1947, consulate or embassy of foreign countries, or any other person or class of person as notified under the section 55, entitled to a refund of tax paid by it on inward supplies of goods or services or both, may make an application for such refund in such form and manner as may be prescribed before the expiry of the 2 years from the last day of the quarter in which the such supply was received. Subsection 3. Subject to the provisions of the subsection 10, a registered person may claim refund of any another unutilized input tax rate at the end of any tax period, provided that no refund of unutilized input tax rate shall be allowed in cases other than zero rated supplies made without payment of tax, where the credit has accumulated on account of the rate of tax on the inputs being higher than the rate of tax on the output supplies other than nil rated or fully exempt supplies, except the supplies of goods or services or both, as may be notified by the government on the recommendation of the council. Provided further that no refund of unutilized input tax rate shall be allowed in cases where the goods exported out of India are subject to the export duty. Provided also that no refund of input tax rate shall be allowed if the supplier of the goods or services or both avails of the drawback in respect of the central tax or claims refund of integrated tax paid on such supplies. Subsection 4. The application shall be accompanied by such documentary evidence as may be prescribed by to establish that the refund is due to the applicant, and such documentary or other evidence, including the documents referred to in the section 33, as the applicant may furnish to the establish that the amount of tax and the interest, if any, paid on such tax or any other amount paid in relation to which the refund is claimed was collected from or paid by him, and incidence of such tax and interest has not been passed on to any other person, provided that where the amount claimed as a refund is less than 2 lakhs rupees, it shall not be necessary for the applicant to furnish any documentary and other evidence, but he may file a declaration based on the documentary or other evidence available with him, certifying that the incidence of the such tax and the interest has not been passed on to any other person. Subsection 5. If on receipt of any application, the proper officer is satisfied that the whole or part of amount claimed as refund is refundable, he may make an order accordingly, and amount so determined shall be credited to the fund referred to in section 57. Subsection 6. Notwithstanding anything contained in the subsection 5, the proper officer may, in the case of any claim for the refund on account of the zero rated supply of goods or services or both, made by the registered person, other than such category of the registered person as may be notified by the government on the recommendation of the council. Refund on the provisional basis 90% of the total amount so claimed in such manner and subject to such conditions, limitations, and safeguard as may be prescribed, and they after make an order under the subsection 5 for the final settlement of the refund claim after due day verification of documents furnished by the applicant. Subsection 7. The proper officer shall issue the order under the subsection 5 within 60 days from the date of receipt of the application, complete in all respect. Subsection 8. Notwithstanding anything contained in the subsection 5, the refundable amount shall, instead of being credited to the fund, be paid to the applicant if such amount is relatable to the refund of the tax paid on the export of the goods or services or both, or on the inputs or input services used in making such exports. Refund of unutilized input tax credit under the subsection 3, the refund of tax paid on supply which is not provided either wholly or partially and for which the invoice has not been issued, or where a refund voucher has been issued. Refund of tax in presence of the section 77, the tax and the interest, if any, or any other amount paid by the applicant if he has not passed on the incidence of the such tax and the interest to any other person, or the tax or interest borne by such other person, class of applicant, as the government may on the recommendation of the council by the notification specify. Subsection 9. Notwithstanding anything to the contrary contained in any judgment, degree, order, or directions of the appellant authority tribunal or any court or any other provisions of this act or rules made thereunder or in any other law for the time being in force, no refund shall be made except in accordance with the provisions of subsection 8. Subsection 10. Where any refund is due to a registered person who has defaulted in furnishing any returns or who is required to pay any tax, interest, or penalty which has not been stayed by any court, tribunal, or appellate authority by the specified date, the proper officer may withhold the payment of the refund due until such said person has furnished the return or paid the tax, interest, or penalty as the case may be. Deduct from the refund due any tax, interest, penalty, fee, or any other amount which the taxable person is liable to pay but which remains unpaid under this act or under any existing law. Explanation: for the purpose of this subsection, the expression specified date shall mean the date for filing an appeal under this act. The subsection level, where an order giving the rise to the refund is subject matter of appeal or further proceedings, or where any other proceedings under this act is pending and the commissioner is of opinion that the grant of such refund is likely to adversely affect the revenue in the said appeal or other proceedings on account of malfeasance or fraud committed, he may, after giving the taxable person an opportunity of being heard, withhold the refund till such time as may be determined. The subsection 12, where a refund is withheld under the subsection level, the taxable person shall, notwithstanding anything contained in the section 56, be entitled to the interest at such rate not exceeding 6%, as may be notified of the recommendation of the council if, as a result of appeal or further proceedings, he becomes entitled to the refund. Subsection 13. Notwithstanding anything to the contrary contained in this is section, the amount of advance tax deposited by the casual taxable person or non resident taxable person under the subsection 2 of the section 27 shall not be refunded unless such person has, in respect of the entire period for which the certificate of registration granted to him had remained in force, furnished all the returns required under the section 39. Subsection 14. Notwithstanding anything contrary contained in this section, no refund under the subsection 5 or the subsection 6 shall be paid to an applicant if the amount is less than 1000 rupees. Explanation for the purpose of this section. Refund includes refund of tax paid on the zero rated supplies of the goods or services of both or inputs or input services used in making such zero rated supplies, or the refund of tax on 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 supply of the goods regarded as a deemed export, or the refund of unutilized input tax credit as provided under subsection 3. Relevant date means in the case of goods exported out of India, where the refund of the tax is available in respect of the goods themselves, or as the case may be, the inputs or input services used in such goods. If the goods are exported by the sea or air, the date on which the refund, the ship or aircraft in which the such goods are loaded leaves India, or if the goods are exported by land, the date on which the such goods pass the frontier, or if the goods are exported by the post, the date of dispatch of the goods by the post office concerned to the place outside India. In the case of supply of goods regarded as a deemed export, where the refund of the tax paid is available in respect of the goods, the date on which the return relating to such deemed export is furnished. In the case of zero rated supply of goods or services or both, to the special economic zone developer or the special economic zone unit, where a refund of tax paid is available in respect of such supplies themselves, or as the case may be, the inputs or input services used in such supplies, the due date or for the furnishing of the returns under the section 39 in respect of the such supplies. In the case of services exported out of India, where the refund of tax is available in respect of services themselves, or as the case may be, the inputs or input services used in such services, the date of receipt of payment is convertible foreign exchange for or in Indian rupees, wherever permitted by the Reserve Bank of India, where the supply of services has been completed period to the date of such payment, or the the issue of invoice where the payment of services has been received in advance period to the date of issue of invoice. In the case where the tax becomes refundable as a consequence of judgment, degree, order, or direction of appellant authority, appellant tribunal, or any court, the date of communication of the such judgment, degree, order, or directions. In the case of refund of unutilized input tax credit under the class 2 of the first proviso to the subsection 3, the due date for furnishing of the returns under the section 39 for the period in which the such claim for the refund arises. In case where the tax is paid provisionally under this act or the rules made thereunder, the date of adjustment of the tax after the final assessment thereof. In the case of the person other than the suppliers, the date of receipt of goods or services or both by such person, and in any other case, the date of payment of tax. The Central Goods and Services Tax Amendment Act 2018, dated 30th August 2018. This is the refund section, friends. Section 54 is the refund section. Then section 55, refund in certain cases. Refund in certain cases, the government may, on the recommendation of the council by notification, specify any specialized agency of United Nations organization or any multilateral financial institution and organization notified under the United Nations Privilege and Immunities Act 1947, consulate or uh, embassy of foreign countries, and any other person or class of person as may be specified in this behalf, who shall, subject to such conditions and restrictions as may be prescribed, be entitled to claim refund of tax paid on the notified services of goods or services or both received by them. This was section 55, friends. Now we will be reading 56. Section 56, interest on delayed refund. As we understood earlier that if there is a delay in the refund of, then the government is bound to pay the interest at 6% per annum. So that only we are going to read here. If any tax ordered to be refunded under the subsection 5 of the section 54 to any applicant is not refunded within 60 days, please note down the word within 60 days. The refund has to be there from the date of receipt of the application under subsection 1 of that section. Interest at such rate not exceeding 6% as may be specified in the notification issued by the uh, by the government on the recommendations of the council shall be payable in respect of the such refund for the period of delay beyond 60 days from the date of the receipt of the such application till the date of the refund of the such tax to be computed in such manner and subject to such condition and restrictions as may be prescribed, provided that where any claim of refund arises from the order by an adjudicating authority or appellant tribunal or the court which has attended the finality and the same is not refunded within 60 days from the date of the receipt of the application filed consequent to such order, interest at such a rate not exceeding 9% as may be notified by the government on the recommendation of council shall be payable in respect of the such a refund for the day from the date immediately after the expiry of the 60 days from the date of the receipt of the application till the date of the refund. Explanation for the purpose of this section: where any order of the refund is made by the appellant authority, appellant tribunal, or any court against an order of the proper officer under subsection 5 of the section 654, the order passed by the appellant authority, appellant tribunal, or by the court shall be deemed to be an order passed under the subsection 5. This was about the refund that we can get within 60 days, friends. Uh, then, Consumer Welfare Fund. Consumer Welfare Fund, Section 57. The government shall constitute a fund to be called the Consumer Welfare Fund, and they shall be credited to the fund the amount referred to in the subsection 5 of the Section 54. Any income from the investment of the amount credited to the fund and such other monies received by it in such manner as may be prescribed. Then the section 58, utilization of the consumer welfare fund. The subsection 1, all sums credited to the fund shall be utilized by the government for the welfare of the consumers in such manner as may be prescribed. Subsection 2, the government or the authority specified by it shall maintain a proper and a separate account and other relevant records in relation to the fund and prepare an annual statement of accounts in such form and manner as may be prescribed in consultation with the computer and Auditor General of India. These were about the refunds which we have discussed. So, this is for today. Thank you very much and catch you tomorrow.